We are going to start with case number 28839, State of Ohio versus Antonio Parra. Now, the state has waived arguments, so we will hear arguments from Mr. Parra's attorney, Mr. Medvick. He'll have 15 minutes. Attorney Medvick, we've read the briefs and are ready to proceed if you are, sir.
Thank you very much. Good morning. May it please the court, I am Alan Medvick. I represent the appellant here, the defendant at trial, Antonio Parra. The trial proceeded on numerous issues, but Mr. Parra was clear to most of those, so there are no real trial issues. The one issue that I've raised here and one assignment there is regarding the failure to suppress evidence of the gun after the initial stop, when all parties were outside the vehicle and there was no indication of danger or that the client had expressed statements that the clients were not to be arrested, but for after the search, the finding of a firearm in the glove compartment of the car. The state points to some case law out of the 10th district and this district regarding interpretations of Gantt that the appellant and myself simply believe to be wrong. The Arizona versus Gantt decision and the Michigan versus Long decisions, I think, are clearly dividing Supreme Court precedent in this matter. The Long case allows for a protective sweep of a vehicle when the defendant or the person stopped. There is a clear and articulable reason why that defendant is presumed to be dangerous, and there are facts present to necessitate searching the vehicle for the protection of the officer. The Gantt case, which was decided considerably later, I believe Long was 83, and Gantt was 2009.
Of course, in this case, the initial call was there was a shooting, correct?
The initial call was there was a shooting, but I believe that the trial counsel, Joe Gorman, clearly elicited from the officers that there was no indication that these parties were going to, either the driver or Mr. Parra were going to be detained after being removed from the car and investigated and interrogated and spoken to, and would have been returned to their vehicles and allowed to leave at that time, except for a subsequent search.
I think the state's argument is they would be allowed to return to their vehicle, and if there was in fact a gun in there. And
that's exactly my issue with this case. You're absolutely right. That is their argument. And I think that not only ignores Gantt, it eviscerates it, and what was to be a restraining decision on the prior cases of Benton and Long, which allowed for these protective sweeps. And Arizona versus Gantt is on very similar facts, where the suspects were removed from the vehicle and then they subsequently held a protective sweep. And in that case, those clients were already under arrest. Here, the argument is that there is no reason to arrest the clients, and therefore they somehow pose a greater danger to the police than defendants who are already being detained or who have already shown the clear evidence of danger. The police officers themselves have stated that that there was no reason to detain these persons. And so what becomes, I don't see where there's any sky left between Gantt, where you can, where you're going to arrest someone, and then presumably you still have a right to an inventory search, you have a right to other means of searching the vehicle, probable cause for contraband, other evidence that would exist, or in this instance where you are not going to arrest someone, and you would then return them to a car so that Gantt does not apply because they're not under arrest. I believe that is counter to the intention of Arizona versus Gantt, and the cases out of Ohio that have held that largely out of the 10th District of Brock and Pamey, and they cite to Wade here, and there have been a couple others out of the 9th as well. I recognize that this is not the first time this court has stomped that ground. I believe that those not only ignore but run counter to the intent of Arizona versus Gantt. The 8th District has a number of cases that have been held on this issue, and those that have addressed Gantt find some other reason to uphold the search. They either there is no good reason for the search and that the suppression is maintained, or there is a probable cause that there's contraband in the car, there is articulated reason for a belief that that the defendants are dangerous, or there is or there's an immaterial search subsequent to an arrest. Those are the other articulable reasons. We think what has essentially happened here in Ohio subsequent to Gant is we created a presumptive right to search a vehicle that is only overturned if you actually arrest someone outside the vehicle. That seems unconstitutional and an impossible application of the Gant holding. And I'm not disputing that other courts have found that, and I'm not arguing, I don't have a clear case to point to that would be a disputed issue if this court were to hold separate in the eighth. I mean, they've not articulated this issue in that way, so I don't know that I could ask for this to go up by finding a dispute between the districts. But the facts are clear, and the evidence elicited at the suppression hearing are that there was no intention to arrest, and the officers did not feel they were at danger, and that there was no articulated basis that they were searching the car based on probable cause for contraband. That can't be their basis. Their sole issues were a concern and a protective sweep. Appears to be what was elicited. That is the position that I listened from, that I found in the suppression hearing, and I think is reflected in the decision of the trial court, that they expressly refused to apply Arizona versus Gant because in this instance the officers had decided they were going to allow these people to return to their car, which is it's a catch-22. They either are under arrest because they have committed some crime, or they are at risk of danger because they've not committed any crime. That means that any of us driving down the street, we are removed from our vehicle and allowed to return, are now at risk of harm and a risk of danger to an officer. It creates, at its broadest application, and I don't see where there's any limitation in that, a presumptive right to search your vehicle. And I think that is a problem, a slippery slope at worst, or at best at this point. I think that we may already be at the bottom of that slope based on this decision.
So at the hearing, did the officers testify?
The officers did testify.
Or did they testify that they did not
And I believe,
feel they were in danger? Or
and I believe that they testified that what you will hear is that they testified that they wanted to search the vehicle so that they could make sure that there was no, but they also testified expressly that they were going to allow these people to return to the car, that they were not.
what do they say about fear for their own safety?
And I believe that you'll have to read Officer Coates, I believe the cross-examination by Joe Gorman, where I don't know that they had any articulated feeling of risk. They were searching because they were going to allow, the way I read it, it is a policy decision when they're returning someone to a car, they're going to search.
So you're saying they didn't necessarily testify that they weren't afraid, they just didn't testify that they had reasonable grounds to be
But,
afraid?
and I think that they have to testify that there are, I mean, the long decision says that you can do protective sweep when there are clear and articulable reasons, articulable facts that the person is a threat to the safety of the officer returning the vehicle. And even in the vehicle that even under Michigan versus Long, when they were doing protective sweeps, that they had to have articulable facts. That's a burden on the state, on the officers, not on the.
But do they have to actually say, subjectively, I felt that I was at risk?
They
Because
have to be
there's-
able to articulate what those facts are, and I believe that they would have to, I believe it's a reasonable person standard. They have to present those facts.
And that's what I was getting at, because here you have, you know, a 911 call with the shooting.
Yes.
They felt like this SUV or whatever it was mashed completely. It was in the vicinity. Then the defendant here, the appellant, evidently gave him kind of a hard time about even getting out of the car. As far as he carried.
And I don't believe that is true. I believe the officers, all parties were, and the officer's testimony is that all parties were responsive. They had their hands seatbelt. I believe what his issues were that he was detained in the seatbelt and was in a bit of a catch-22, wanting to figure out how to unlock the seatbelt and get out of the car without moving his hands. And I believe as you read the transcript, you'll find that I don't think he was uncooperative or belligerent or threatening in any way. I think he was trying to figure out how to comply with the officers while in a heightened situation.
Counsel, let me ask you, the trial court found that your client didn't have standing to challenge the search of the vehicle. Now, that issue was not challenged on appeal. How, if in any way, does it affect your appeal?
I believe that my client that becomes again, that is a catch-22. How do you?
That's why I asked you.
I mean, how do you find that my client lacks standing for a gun that he is for a gun in a car that is not his and is subsequently charged for possession of the firearm that is then presumed to be his because it was in a car that he did not have. I mean, I think his property, he put it in the glove compartment, I believe he should have. And you're right, that was not raised on appeal.
Yet it was found,
But I believe that,
obviously the driver had standing. And I'm
Yes.
not saying whether your client
but the
did.
driver was not
did or
charged,
didn't.
there was no.
But that would have given reason to find it, and then
Yes.
your client was charged. So it's interesting conundrum.
Yes. Yes. So,
And Judge Callahan raises a very, very good point, because you just indicated that that issue is not raised on appeal, so what are we supposed to do with it?
and I would ask you to consider that at plain error, if that is where, that is. And I would obviously, if that becomes this court's determination, I'll have that conversation with my client about how to proceed.
You have 2 minutes and 10 seconds.
That's it.
If you want.
At this point, I guess I could, I've stomped this ground pretty hard. If there's any other questions from
Judge Callahan. Anything else, Judge Parra?
No.
this would usually be my
Thank you for your presentation today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail you a copy of that decision once it is made. And you can also check the Ohio Supreme Court's website, which publishes the decisions as well.